What happens if one party to a CBA accuses the other of breaching the agreement? Liz was a bargaining unit employee. Liz's employer suspended her for 2 weeks because she'd violated safety rules by driving a forklift at excessive speeds. The applicable CBA allowed the employer to suspend employees only for just cause. Liz claimed that she wasn't driving too fast and that the employer's speed limit rules were unclear. If Liz was right, her suspension violated the CBA. What could Liz do? Theoretically, Liz could file a federal lawsuit against the employer. NLRA Section 301 allows an employee, an employer, or a union to file a lawsuit in federal court for breach of a CBA. More likely, however, the applicable CBA included a grievance procedure requiring the parties to submit contractual disputes to binding arbitration. Virtually every CBA has such a provision. In a famous trilogy of cases known as the Steelworkers Trilogy, the Supreme Court recognized that federal policy favors labor arbitration over litigation. Before filing a lawsuit, an employee generally must first exhaust the CBA's arbitration procedures, unless the union has breached its duty of fair representation. Therefore, Liz would probably have to file a grievance instead of a lawsuit. Suppose Liz filed a lawsuit, even though the CBA required arbitration. Could the court order her to arbitrate? Yes. Federal courts may compel parties to arbitrate pursuant to a CBA's arbitration provisions. Thus, if a party to a CBA refuses to arbitrate a dispute that falls within the contract's arbitration clause, the other party may sue to compel arbitration. In such cases, courts apply federal common law. An employer's agreement to arbitrate is considered a quid pro quo for a union's agreement not to strike.